All right, we'll bring the May 12th, 2025 City Council work meeting to order. First item on the agenda, Gimple IUP discussion.
Mr. Mayor, I'll have the attorney set this up and then we'll get into some of the details.
Mayor, council members, first agenda item for the work session is the Gimple interim use permit. Tammy Gimple has 3 interim use permits. City administrator has provided me 2. One has to do with the use of 2 horses, resolution number 2019-55. It's an interim use permit that allows the applicant to have up to 2 horses. It has 5 conditions, one of which is that the applicant must comply with the city's farm animals code, also must expand fenced pasture to 3 acres. The permit does require, as a standard with IUPs, that when the property is sold, the interim use permit will immediately expire, or if there's non-compliance with IUP conditions. The property owner also has 30 days to remove approved domestic farm animals upon expiration of the IUP, and that's fairly standard as well. As upon expiration, there's a time period to essentially bring back into compliance after the expiration of the IUP. 30 days is fairly standard, but it can be shortened or extended depending upon the circumstances. 5th condition is that the property may be inspected and evaluated annually by city staff. And IUPs are customarily evaluated on an as-needed basis. Some of them do require annual evaluations and inspections. And the 6th is all conditions, unless otherwise specified, must be met by February 28th of 2020. The second IUP has to do with permitting animal contractual services on the property. This is resolution number 2021-74. There are 12 conditions here. I want to underscore that these are interim use permits, and as a result, unlike conditional use permits, they're personal. They do not run with the property. 5 conditions with respect to the use as an animal contractual services site is that it is going to be non-commercial, that the boarding of dogs is limited to 10 days, at which time any dogs must be moved off-site. All municipal contracts entered into by the applicant must be filed with the city of East Bethel. Even though it's not stated, that's a way to ensure that the use meets the interim use permit and also understand what are the contractual terms and obligations that the landowner must fulfill with respect to the use of the animal contractual services, IUP. The 3rd, or strike that, the 4th, is that standard permit will immediately expire once the property is sold or if there's non-compliance. Again, number 5, as is very standard with IUPs, is the right to inspect. This one actually goes even further, and that is not only the city's designated inspector, but all other personnel under the direction and control of the city. I think it is important to note that the Anoka County Sheriff's Office is under contract with the city of East Bethel in order to undertake all the city's necessary and reasonable law enforcement and public safety activities. And that access must be allowed for inspection purposes upon 12 hours notice to ensure compliance with all applicable conditions. Number 6 is the annual inspection by the Minnesota Board of Animal Health. Number 7, kennels for quarantined dogs must not exceed 15. Housing enclosures for the dogs must be located in an enclosed facility. I think number 7 is important when you take a look at also the limit with respect to the dogs, so that there's a time period of quarantine of dogs of 10 days, and then there's a limit as far as the overall number, number 7 of 15. Housing enclosures for the dogs must be located in an enclosed facility. All dogs must be confined to the premises. Accumulation of feces must be removed. And then it goes on as far as other particular keeping the premises in good sanitary and sightly condition. Number 11, City Council reserves the right to modify conditions of the IUP at any time where deemed appropriate. Actually, that's true under any IUP, but it's nice to have it expressly noted here under number 11 nonetheless for the Animal Contractual Services IUP. Number 2, or strike that, 12, Gratitude Farms will be required to request an amendment to the IUP in cases where contractual service obligations exceed the parameters of the IUP. Again, that kind of relates back to making sure that the city has on record all the municipal contracts and make sure that those municipal contracts are within the limits of the IUP and provide that oversight as well. So one of the things that jumped out at me when actually I received these 2 IUPs from the city administrator is actually the dates. The first IUP with respect to the 2 farms is 2019, and the second one is 2021. Now, it is fairly common for IUPs not to be amended during a, basically 16 or 14-year time period. But it is also very common through annual inspections and change circumstances and conditions and things, change over time within the city or within the site or within the use and so forth, for the IUPs also to be amended to reflect those changes. Those changes can be either initiated by the property owner themselves because of those change circumstances, or also fairly common by the city as they go through inspection processes and so forth and realize that conditions need to be changed, tightened up, and so forth. Therefore, the first thing that jumped out at me is going, this has been a long time period for these IUPs to essentially not have been changed, just separate and apart from any circumstances that occurred within the last year or so. That being the case, I also understand that essentially what has transpired with starting at the beginning of this year and so forth is one of the trigger points for this particular discussion. And the discussion for the City Council is basically really to decide whether they're going to take any actions with respect to the IUP, or if they're going to take actions, then actually the action today. And the limitation for the council is to direct city staff to place it on the necessary agenda and go through the proper notice proceedings with respect to taking action on the IUP. So the decision today is not whether the IUP is going to remain in place, or whether it's going to be amended, or whether it's going to be revoked. That is not before the agenda, and that is not within the power of this particular body today. The power within this body is to decide whether such action should occur, and then go through the necessary steps. That's why this body is not going to be taking evidence or testimony or those things, because that is through a public hearing process. That is where you put the holder of the IUP on notice that the council is looking at either amending or revoking, putting that notice either before the Planning Commission, and this body can decide to send it to the Planning Commission, or have it directly come before the City Council for such action. So, as I understand, what has triggered this particular discussion is a series of events that started on January 26th of 2025, where the Anoka County Sheriff's Office responded to a call in the township of Linwood. And the township of Linwood does have a contract with Tammy Gimple with respect to taking and sheltering animals, one of the municipal contracts that the applicant has, or the holder of the IUP has. Such animals were brought to Ms. Gimple, and then in a follow-up, the Sheriff's Department needed to undertake further investigations with respect to the care and condition of those animals to determine whether there had been abuse of those animals by the original property owner. And at least as alleged by the Anoka County Sheriff's Department, despite repeated requests, they were denied entry in order to undertake the inspection. As a result, according to the Anoka County Sheriff's Department, they needed to get a search warrant in order to do so. As a result of a series of steps taken by Ms. Gimple with respect to refusing entry onto the property, refusing to provide information upon request in a timely manner, or provide all the information upon request. Eventually, the Sheriff's Department referred it for criminal prosecution. That criminal prosecution resulted in a summons complaint that was issued on or about March 12th of 2025. And that summons and complaint contains 2 counts. State of Minnesota versus Tammy Ann Gimple, located at 22359 Batten Street, Northeast, East Bethel, Minnesota, 55011. The 2 counts are: 1, charge, theft, take, use, transfer, movable property without consent, in violation of Minnesota statutes section 609.52.2, subdivision 1A. It's a gross misdemeanor. Date of the offense is January 29th of 2025 to February 10th of 2025. Count 2, obstruction legal process, lawful execution legal process, in violation of Minnesota statute section 609.50, subdivision 1.1. Misdemeanor offense. Offense date also January 29 of 2025 to February 10, 2025. Now I want to make it very clear that right now, as we well know under the United States Constitution as well as our state constitution, a person is presumed innocent until found guilty. So these are just charges, these are just allegations. And what I have summarized, of course, in a very summary fashion is the basis for that. What is clear is that under the IUP with the city of East Bethel, an inspection of her premises to ensure compliance with IUP is one of the conditions. And what is also clear, at least as alleged by the Anoka County Sheriff's Office, is that the Anoka County Sheriff's Office was prohibited by the holder of these 2 IUPs from undertaking inspection. At this point, the disposition of the criminal action and so forth is still in process. And so, not sure exactly how it's going to occur. Also want to make it very clear that I believe Ms. Gimple is here. And this is not a criminal proceeding, and this is not a proceeding whatsoever. This is discussion by the council as far as whether any steps, if any, are to occur. But that if there should be an opportunity permitted by the mayor for Ms. Gimple to say anything, that any statements she says can and may be used against her. Now, I don't have that obligation to provide her those Fifth Amendment rights, but I think it's very important nonetheless, given the fact that there is these criminal proceedings, to make that very clear. Also make it very clear that when and if the city does undertake any type of civil actions and so forth, that's a different standard. The city has full rights to oversee its code and ensure compliance with IUP, and can take any reasonable action amending it, adding in additional conditions, and if appropriate and found that there is basis for noncompliance, to also revoke. With that, I certainly would be open to any questions, but I think that I've teed it up at least as quickly as I can for the council to engage in the discussion as to whether they're going to take no action or whether they're going to refer to staff for proceedings with respect to what actions would be appropriate based upon the facts and the record. Mayor?
Mr. Look, do you got any further information on any violations?
Mr. Mayor and Council, again, just want to reiterate this is a conversation that we're having this evening. I do not want to confuse this with code enforcement, notifications of code enforcement, or the process that the city takes to enforce any sort of violations in terms of code enforcement. These IUPs are essentially a contract where the city approves an interim use permit conditioned on whatever is written, okay? So what I want to do is just kind of go through these two. There's three of them, 3 IUPs in total. I'll differentiate between those, but essentially there's the integrity of the city, which is at stake right now. We have multiple IUPs that are out there. When the city comes into knowledge of the fact that an IUP applicant may be in violation, I think it's incumbent upon the city to follow up on that, and that's precisely what we're doing here. And whether or not you want to take that to the next level is your decision. Obviously, there's a range. There's a range of don't do it again to revocation. But just taking the first one here, I think the easiest one is, well, just by the older resolution of 2019-55. It's a resolution granting an interim use permit for the keeping of 2 horses on the property located at 22359 Baton Street Northeast with the PIN number there. I drove by that property. I counted 8 horses that I could see. So there's, and again, our code is kind of set up for acreage and pasture land and the amount of space that the city at one point deemed was necessary for raising of horses. And whatever the case is, the number was established at 2. There are more than 2 on that property as of the date in which I took that picture. The second resolution 2021-74, is a resolution granting an interim use permit for the operation of an animal contractual service home occupation on property located at the same address, 22359 Baton Street Northeast. And the attorney kind of went through the conditions set forth in that, and I would like you to zero in on 4 in particular. The first is, as was alluded to, the city's designated inspector and any other personnel under the direction and control of the city whom the inspector believes necessary must be allowed access for inspection purposes upon 12-hour notice to ensure compliance with all applicable conditions. The sheriff's office, as I understand, it took them 3 days to request access to this property. As I was told, the condition of the animals need to be verified so that if prosecution was necessary for the individual in Linwood, they would have their reports completed, et cetera, pictures taken, whatever was necessary to do that. And from what I understand, the woman in Linwood is, did I say East Bethel? The woman in Linwood is an elderly woman, and they'll probably take some grace in that, but I think this is part of the process that's necessary to determine that the dogs can't be returned to her, or whatever the disposition might be of that. So eventually it led to a warrant, as was indicated. From what I understand, the sheriff's department arrived on scene and the dogs were not there, which leads me to the condition number 9, which was all dogs must be confined to the premises. I believe the reason for this is because Gratitude Farms goes through kennel inspection reports by the Minnesota Department of Health. This is one that was conducted on December 15, 2023. This is to ensure that the animals are going to be properly cared for, have a proper area clean, et cetera, to take care of them. If the animals are removed and taken to other locations, those other locations are not licensed. And there is no guarantee that that those other locations have what it takes to keep these animals properly. I think you know, whether it was the horses or whether it's this animal contractual service home occupation, you know, if there was any sort of limitations that the IUP holder felt prohibited her from doing her work as she needed to do. Item 12 essentially says that she's required to request an amendment to an IUP. We just can't have people in a, I guess, decision of their own just go and start changing the conditions of the IUP and operating how they see fit. They need to come back in front of this body to say, this is the reason why this doesn't work, or this is the reason why I need to add more conditions, or whatever the case is, or alleviate conditions so that things can be done. I would say at the very least, under item 11, it says the city council reserves the right to modify conditions of the IUP at any time where they deem appropriate, and I would suggest that there's probably some conditions that need to be modified if this IUP is not revoked in the future. So that, Mr. Mayor, is the information that I have on this. Again, if it's something that, you know, I believe that 2021-74, while it relates to the court decision, I don't know that it's going to affect the outcome of that court decision. I think they have what they need. I don't think this discussion will have bearing on that. But nevertheless, I think this discussion is necessary, again, to preserve the integrity of not only the other IUPs that are out there and the individuals that are following their IUPs, but also the integrity of the authority the city has. So we'll stand for questions if you have any.
I think at this time, council members, it's time to discuss, if got any discussions coming on.
Do you have pictures of the horses that you're talking about?
I do on my phone, yes. I can make those available at a public hearing if you'd like.
Has there been any letters sent out for notice of any violations on this property?
Mr. Mayor and Councilmember Mundell, it is not required as a condition that we send letters out for violations. It's incumbent upon the applicant at that time and the person agreeing to the conditions that they follow the conditions. I did send an email saying that we were going to have this discussion this evening as a courtesy to the owner of the IUP so that they could be present here and defend themselves or answer questions if you had questions. But it is not customary that we send out. That's why I said in the beginning, it's different than code violations. Code violations, there's a specific process where you have to send, I believe it's 3 letters and follow the process through and before you can go to any sort of court proceeding. In this particular instance, you as the body get to decide if there are violations, if they are legitimate, and what the outcome should be of that.
So what would be the next step? Do we have to make a motion to bring this up at a future meeting for a hearing or something like that? What's the next step?
Mr. Mayor, Councilmember Urkel, the next step would be if there's a consensus of the council to bring it to, we could bring it to the May 28th meeting if you like. Council can prepare a case for that. We can have a public hearing. Photos can be provided at that time. You know, there would be no motion, no decisions here this evening in terms of formal motions, but a consensus, we would direct staff to do that.
Personally, I think we should go to the public hearing, and hopefully maybe her court is done, I don't know, but I would like to hear the whole, I would like to hear the whole story, see the pictures, everything. So, and that's what a public hearing would do.
Anybody else?
Can we get copies of the IUP?
Yep, we'll send those out, sure.
So, excuse me. moving forward, as Ms. Urkel would like, is that the consent here, or?
Sure.
Okay.
Okay.
I believe we'll, put this up for a public hearing at the next meeting then.
For the record, all council members and the mayor nodded in the affirmative.
Oh, yeah, good point.
Yeah.
In the meantime, if you can provide us with the pictures and IUP and any other material that you have pertaining to this, and if you can find out an update on their current court proceedings, that'd be beneficial as well.
Okay.
Thank you.
Mayor, council, what is customary is to provide essentially and assemble a packet of information and the documentation for the basis for the action that would be provided to the holder of the IUP, so that individual knows, at least record to date, what it would be the evidence for the city to take action. At the same time, the city, in its own volition, as long as a reasonable basis, can do anything it really wants with the IUP. So the record would be available not only to the city council, but to the holder of the IUP as well. And if there's any additional documentation that other residents provide and so forth, that should be provided, and then in a reasonable fashion would be forwarded on to the holder of the IUP as well.
Okay. All right, with that closed, let's move on to item number 2, fee schedule review.
Mr. Mayor and council members, we generally in January we deal with fee schedule changes that occur, and I know that some of you are probably familiar with those, reviewing those changes. And we generally, as far as fees are concerned, we try to we cannot charge more than it costs us. Generally, we're not charging enough. And so we try and evaluate those fees on an annual basis, certainly, and wanted to just have a discussion here because we're in the process of kind of establishing the budget parameters right now, and we want to get your feedback on what some of the fees that are out there right now. Particularly, we're looking at planning and zoning fees, variances, code enforcement fees, in particular. Planning fees, I know we've had some phone calls recently here as it relates to some of Kendra's work. We generally, whether the attorney works on it or Craig Yoakum works on it, our engineer, or now if Kendra works on it, it generates an expense to the city. And so these expenses, some of which can be absorbed, and some we bill back to the applicant. In terms of planning and zoning fees, I know that we charge an escrow of $300, for example, and in some cases, the cost for planning and zoning is coming in at $3,000. Okay, so we have a significant, cost above and beyond what we're charging for some of these applications. Some cities have an on-staff planner. We have an on-staff planner, but she's newer and certainly coming up to speed. Hence the reason why we have Kendra kind of acting as a backup right now. She is rolling into more of a call me if you need me and I'll bill you on an hourly type of basis for that. But as Grace comes up to speed and more confident in the work she's doing, I think that'll start to fall off. Some cities charge for, even if they have on-staff planner, they charge for the planning costs. So for example, you come in and you want to rezone your property. Nobody's forcing you to rezone that property. You want to rezone it. There's a cost to the city for doing that. And so the decision that you folks get to make then is it the responsibility of the entire city to absorb this cost of a rezone, or does it fall upon the person who wants the rezone? And do you want to capture some of those fees? That's one of the questions that we have. Variances are another situation. You want to put in a second driveway, or you want to build a larger than code allows for secondary structure of some sort. No one's necessarily holding a gun to your head to build that driveway or to do that, but there is a cost associated in making sure that everything's reviewed and everything comes out properly, so that when it's recorded, it's going to be a legal document that'll withstand a process of sale, or going through any sort of record search or anything like that. So that's kind of the question that's here before you today. We have a couple other fees. I know Carrie's brought up one of these fees where it takes two, I forget the exact situation, but it takes two publishings with the county at $30, $40, $50, whatever it is a time. We only charge for one. So those type of things where do we want to reevaluate this? Do we want to capture the cost as opposed to spreading it out amongst the entire population of East Bethel? Just want to get your feedback on that.
I've taken a few of these phone calls about people who pay a fee and then get a bill that's 2 and 3 times as much. I think it boils down to a communication process or lack of. Not informing someone that this extra work might take some time and some resources from the city. I think the other thing it involves is that when you have someone who's in a position and this is what their job is, and in some people's mind, even mine in the beginning, I'm thinking this is what they're supposed to be doing here at the city. If someone comes in and asks that question, this is what their wages are for. Could you explain a little bit why that's not exactly what's happening, why the extra cost is actually there?
Mr. Mayor, Councilmember Miller, first of all, let me touch on the first issue. Yes, it was a failure to communicate in the very beginning. We have since changed a form to say that this is the escrow, this is the application fee, and there will probably be other fees associated with this. I've even asked Grace to kind of ballpark. We just had a variance come through, and that cost that person X amount, and that could be similar to your case in terms of the amount of work that's required. Some variances fly through, others require a significant amount of work from staff. To touch on the second issue, there are certain staff functions that, for example, my work here at the city gets absorbed by everybody. There are other things where, you apply for a fire permit or something like that, you pay a fee on that. There are fees associated with some of the work that staff does. It's not out of the in other words, other cities charge these fees. Some do, some don't, and that's the question. That's the question as to if it doesn't cost very much to apply for a variance, you might have a lot more applications for variances. And then if you have so many variances and so many applications, pretty soon you're short-staffed to the extent that you need to add another full-time employee to handle these continual requests that are coming through. So it has somewhat of your ripple effects in a pond in terms of, to the applicant, it's just it's fill out this paperwork. The process involved behind the scenes of trying to make sure that comes before the planning comes, you pay your planning commission members, you advertise appropriately for it, you have to then register it with the county, costs associated with that, if legal's involved, if there are various different things, it can be, cheap to what you're seeing, some of those expenses that are out there, like the Blanco project that's coming through has had a significant amount of back and forth. So the question then is it incumbent upon the applicant to pay that, or does the city get the pleasure of absorbing it?
So can I ask a question? Could it be itemized so that my thinking is every fee is a tax from the government. It's a tax. And I am probably the most anti-tax person up here. But that being said, if we could make it just, for instance, whoever's doing development, because their stuff is huge, but what's on private properties, now rezoning, I wouldn't mind having a rezoning, letting those people, resident or developer, whoever, pay whatever that cost comes up, but for it being on somebody's personal property, if they want to build a pole barn or a barninium, it's not coming out right, but then I say no, absolutely not. It is the city, their taxes are paying this whole city anyways, so that's where I stand. I think that developers and some bigger projects like rezoning, but I would like to see it itemized in, where the council can say yes, yes, no, 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 that kind of thing.
Mr. Mayor and council members, it's always itemized. You may not see it as itemized, but everything is broken out in terms of what category it's going to be billed as from an accounting standpoint.
I meant the fees. The
Right,
fees
right.
itemized.
Yep,
So,
all the fees are itemized so that if the city is paying for it, what budget is that coming out of? Is it coming out of the legal fund? Is it coming out of, wherever? I mean, there's a myriad of different accounts that we have to track these things. So that can certainly be provided. And this is precisely the discussion. It's like, in this situation, it's fine. But perhaps in a barnuminium situation, you want 20-foot walls, which aren't standard, and it's going to require going through this extensive process. Whereas if you're told up front, yeah, we can work you through this process, that's not a problem. It's going to cost you potentially $3,000 to do that. Then the customer can make a decision.
Right.
Do they really need the 20-foot walls, or do they think it's a simple process to get done?
I agree with what Suzanne's saying. Our residents, for their own personal property, like a $300 charge to do it is fine, but if it's just normal things, you know what I mean, versus developers and stuff like that where there's a lot more entailed with it, different story. We can't be raising prices on our residents. I feel the same way. It's like we're already paying staff. Our taxes are covering that. Staff is paid to do that job, so we shouldn't be charging over and above. That's how I look at it. Different story when we got businesses or developers or some huge projects. That's what I got.
Well, I think it's important that our residents know exactly what they're paying for, period. If we charge $300 to put a pole barn on, to overlook the plans for a pole barn on a private residence, how does it get up to $1,200? I mean, they've got to know exactly what they're paying for. And correct me if I'm wrong, are we starting to build back developers now? We didn't do that in the past, did we?
Yeah.
So we started doing that, so that's going to help.
Well,
But I mean, we shouldn't have to do that with the residents, though. I agree with Jim on that one,
Yeah, there are two types of developers. There's the, shall we say, a professional developer like Capstone, which is aware of all the costs associated. They don't have an issue with it. And then there's the private developer that got into development of some land that they own, but they really don't know how to develop this, and they don't prepare things. I mean, the additional work required by the city is essentially doing the work that they would have to do, but they're not providing it because they don't know how to do that. Or you have a situation where somebody wants to put in a pole barn. They get plans drawn up. It's too close to the property line, or it's over a septic system, or it's over a bunch of areas, which a lot of that can be caught in plan review, certainly. Now, that's what your application fee is going to pay for, is a plan review and that sort of thing. But these are the additional charges that come up. They come up. We see them more often than not.
But as long as they're aware of it, you know, I'm okay with something like that. I'm not okay with blindly charging people or sending them a bill that, hey, wait a minute, I gave you this amount of money, now it's double or triple that. I mean, that's not okay, and if we can fix that's a big hurdle. You know, that's a big step in the right direction, you know, that communication process. But we're not in a situation of giving money away either. I mean, it's our job to make sure that that dollar here is spent right to the bottom line, so we're not going over or under. We want to be as precise as possible. Are we that far off on some of these fees? Because I've heard before that some cities charge a lot for a pole barn, for example. I mean, in the thousands, right off the, you know, bat. I think Ramsey's one of them. They charge a lot of money for that, and we charge a quarter compared to what they do.
Right. You know, Mr. Mayor and council members, I think with kind of the turnover in that department, we've had now the opportunity to look at these things a little closer. And what was always kind of done in the past hasn't really been increased over time, number one. But number two, when you start looking at the actual costs of it and what you're charging, you start scratching your head wondering, why are we charging this? Because it's not even close to the cost, you know? And that's why I think it should precipitate a discussion as to how do we handle that? Right? It's a serious liability to the city that we can continue doing it the way we've always done it, or we can revisit it and try and determine what's more equitable for the residents. As you know, there's always, we levy X amount of dollars, and there's always more things to do than the dollars available. And so if dollars are going to being sucked up in a certain area as opposed to, being used on things that need to be used on, then you're faced with a difficult decision of raising taxes at some point. No good deed goes unpunished.
So before we contracted with Landform, did we have these costs that I think the last 5 or 6 people have complained about? Because in my time on council and working with the city, I've never had heard of those costs being issued. So are these costs just being developed because of contracting with Landform?
Yeah, Mr. Mayor and council members, before contracting with Landform, we build out contractual services that, whether it's engineering or legal or whatever the case is. That was the way the city did it. You know, if there was a contractual service that something required, they were responsible for that cost. If it exceeded the escrow, the city ate it. Okay. I would say in the majority, we did not bill for Aaron's time at that point. And if we had a planner on staff, we wouldn't have billed for that either. But because we're required to go to a contractual, at that point, do we bill for contractual? This is contractual now. And I think that's where it kind of got sideways, is finance always billed for contractual, and so these bills went out, and I think there's 2 or 3 complainers, justifiably, that came in and said, wait, what's going on here, type of thing. So, one of them, I know you guys, 1 or 2, I know that you said, no, city's gonna absorb that. But then that got us to the point of, again, drafting the paperwork to say additional language on there so that, buyer beware, so to speak, that there are costs associated in doing this. That was not council direction necessarily. That's why we're bringing it through here to try and get that council direction. We can certainly strike that from the form, or we can follow through on it.
Now, I think having it on the form is okay, just for better communication with the client, but in the same respect, I don't think that a resident should have to pay extra for something that happened as a result internally at City Hall. We lost our director in that department. That was unfortunate. The residents should not have to bear the additional cost of that. That's something that falls on the shoulders of the city that So those additional costs, I don't believe they should incur them.
Mr. Mayor and Council, we have a unique situation in that we've hired now a planner, and we still have the contractual costs. So, again, it's,
Yeah, I don't believe that those contractual costs should fall on the residents as long as we're pursuing our planner, which we now have, and another director. So that when we can get a director hired, that we'll no longer have those contractual costs.
I know all the calls I've gotten came after we kind of backtracked on the grazing land escrow deal. There was a couple of them come in right away and wanted theirs back. And I think, like Tim and everybody else has said here, that we got to be upfront with our schedule. It's got to be there in plain black and white, you know, so people are aware the consequences, how it's going to go about, and then they can question it. Why is this and that? And then we have to deal with it then. But I think that it's got to be in black and white right away, so they know what they're getting into.
so let me clarify, Councilmember Mondo, you said it shouldn't fall on the residents.
Personal
Are you
resident.
talking the
The
applicant?
applicant.
The applicant.
Applicant.
So is that different than the mayor's position?
I don't believe so.
I don't think so.
I think we're all, in one way or another, in agreement up here that those additional costs that a resident application should not garner those additional costs, that having to go, because we went with a contractual land form, that those residents that are applying should not bear those extra unexpected costs. Now that we have updated our forms that say buyer beware,
Those should cover the additional costs, though, those forms.
well, if it's any really unusual cost, maybe, but I think we all are in agreement that it should go back to how it was before we started contracting with Landform. Is there any disagreement with that?
No, when it comes to the residents' personal, there shouldn't be an extra fee over that.
Correct.
Businesses, different story, developers, big, even splitting lots and stuff like that, if there's a major, like say that one we just did with 3 lots, that's a different story because there's a lot more into that. But
Correct.
personal residents shouldn't be penalized, in my opinion, for any of that.
Correct, that's how I feel.
Okay.
Any developer, small, medium, large, they can pay additional fees, whatever, billed per cost, per line item, but residents, $300, that's it, that's enough. They pay property taxes, most of these developers don't.
Yeah, I know, I've got another person calling me too right now, who wants to do a simple lot split.
What did you say?
Wants to do a simple lot split. But they butt up to state, county land, and it's a Savannah forest, which instead of just a simple lot split, our code pushes it into a PUD where they gotta do a planned unit development, and it's gonna cost them lots more money. I mean,
Mr. Mayor and Council, in a situation like that, it's probably going to cost the city a lot more money.
Yeah,
So, and that's precisely the discussion, right? I mean, do
Well-
we pass that cost on? Or
it's
is it-
development.
Or do we absorb it?
it's gonna cost us in the long run eventually anyway, cause we're gonna have to update some of these codes, cause they're ancient.
I think one of the hangups that, the people that I've talked to so far has been, well, if they're not working on this up there, what are they working on? Aren't they paid to work on this during their hours that they're here? You know, we're making it kind of seem like this is all after-hours stuff that we're billing out, when we actually are paying someone to be here and do this job.
Yeah, so if I can just kind of explain it, again, there's an application fee. The application fee will cover kind of the plan review, to cover inspection, to go out and inspect the property, that sort of thing. That's what the application fee will cover. Escrow is an amount that is paid that gets reimbursed if not used, okay? Escrow can be used for all of these things we're talking about here. The problem is the escrow is $300. And if we have the attorney fee in there, I forget what your fee is, but that might give us 2 hours of work.
That's more
that-
than 300.
Yeah, I was
Now
gonna say,
throwing the attorney under the bus. Not wise.
just
to do
because he's present, yeah, less than an hour.
that. Less than an hour, there we go. So let's say it's a highly involved topic that needs to be heavily researched. Boom, you're up to $1,200 pretty easy.
Sheep grazing. That got pretty expensive.
So, you know, you look at everyone's time in terms of coming before planning, coming before council, noticing in the newspaper, you know, everything that goes with it, and 300 goes away. Then the applicant comes in angry because they thought they'd get their escrow back. So this is the challenge that we're dealing with, but we can try and draft something up here, kind of based on the conversation here, bring it back, and we can.
So what you're talking about now though, Matt, is like a developer situation, aren't you? Where there's more involved. It's not just a resident that wants to build a pole building or something like that, right? We don't need an attorney to get involved with something like that. I mean, what would a pole building? You know what I mean? Something.
Trying to think of a situation where an attorney might be needed on that. Certainly, there's engineering that's required. You know, if they're putting in a drain field or what's a, you know, review the drain field, suitable soils, et cetera, all of that. $300 is gone in just a whisper. Done.
I understand that. You ain't putting a drain field in a pole building, though.
I don't know. I'm
I
coming
know,
up with
like unless you're
hypotheticals.
doing it on a swamp.
I'm coming up
You
with
know what I mean?
hypotheticals.
Yeah.
But
I'm just talking common sense, easy for the residents. You know what I mean? I
Yeah.
know if there's a different situation completely, I understand. You know, a lot of times, say 9 out of 10, there probably ain't.
the problem is that the applicant comes in, they pay their fees, they start their process, et cetera, et cetera. Pretty soon it grows into something large.
Right.
That's where the cost is associated after the
But
fact.
before it grows into something large, they should be made aware of that, right? Just because we should know enough to be, just to start the process. But then if
Right.
they come up with something different, it's like, well, I just gotta let you know.
Well,
We
that-
gotta get into this.
That's why we're trying this informational portion of it by saying, by the way, just so you're aware, this lot split or whatever the hypothetical is, has cost up to $3,000 or whatever the amount is. You know, just be aware of that and you can be responsible for that.
Right, because of that thought too with escrow money, I mean, you're talking a bigger event versus a resident getting a permit for a pole building. Right.
I'll give you, for example, we had the gentleman that was building his house there kind of across the wetland. They had kind of encroached on wetland. We had to inform them, you can't encroach on wetland. The attorneys got involved. I mean, that was a massive undertaking. What was the reason for that? Well, you had kind of a homeowner that was, you know, weekend warrior, however you wanna say it, trying to save money, I get it. Everyone wants to, try and do it themselves. The problem is some of these things are so complex that the reason why you pay a lot of money to developers is because there's a lot of time involved.
Right.
And if the individual doesn't know how to process that and get the necessary ducks in a row, it kind of falls on the city then, because we can't approve or unnecessarily delay it without trying to get those ducks in a row, and that's where the cost is associated.
No, I understand.
So,
That's all I
anyways.
got.
Well, I don't believe we're gonna get into topic 3,
No, we can bring that to the next one, Mr. Mayor.
so I'll entertain an adjournment of the,
Motion adjourned.
Second.
motion second, all those in favor?
Aye.
Aye. Meeting's closed.